All right, we are live. Hey, that's what we know we're starting out with. Good morning. Happy Wednesday. Thank you guys so much for tuning in to another episode of Two Lawyers Talk Legacy.
Yes.
Before we get right into it, let's talk a little bit about our Learn Biz Entrepreneur Journal, which is now available on Amazon. If you don't have a copy yet, look, we're at the midpoint of the year. You guys need to copy your copy right now.
Yes.
Learn Biz Entrepreneur Journal, a daily touch, now available on Amazon. The link is going to be in the description. So, Lord of mercy.
Lord of mercy.
Let's get into it, guys.
Yes.
Today we're talking about something that I think Lisa and I probably spend the most time talking about when it comes to probate and real estate and issues when it comes to heirs of property. And when I talk about heirs, I'm talking about somebody passes away and they don't have a will. So whatever they have is passing to their heirs,
Yes.
versus if somebody has a will and whatever they have is passing to their beneficiaries. Okay. So we're talking about, can I sell mama's house? And because we're talking about the house, we had to go ahead and take it to the house. Hey. All right, so we had to take it to the house. You already know that we had to have a conversation about these details when it comes to, can I sell mama's house, and some of the problems that come about when we're dealing with heir property.
You're so right about that, Miss Sandy, because I see it all the time, even in real estate. There are people who want to sell Mama Nim's house, and and I look at it, I go look up the property, do a search on the property, and I see that the house is owned by the estate of Mama Nim, the estate of Jane Doe or whoever Mama is. And the heir seems to think because they may be an only child that is automatically their property, and they just want to go sell it in the estate name. Can't do that.
Yes, and unfortunately, our realtor brothers and sisters don't understand that this is a very problematic process when it starts out with just, let me go ahead and get this house listed, without understanding the issues that are going to come about because this person that you're signing this listing agreement with does not have a current interest in the property. So we're going to talk today about some different issues, situations, and some things that you, as the heir to property, things that you need to be mindful of, whether it be dealing with the courts, the lawyers, the realtors, the title company, the extra people in your family that might be also heirs to the property. What happens when somebody passes away that was an heir and they have children? There's so many different issues. So I'll first start, Lisa, let's start with a scenario first.
Okay.
This is the common scenario that I see. I have one person that is the heir to the property. I have obviously no will. Mm-hmm. And this person is like, all right, mom passed away. I'm just going to live in the house and, pay the bills and I'm good. Lisa, what's a problem with this situation already?
You don't own it. It's not your property. You can't sell it. You can't do anything to encumber that property, just nothing. So the minute you try to transfer ownership or sell it or add somebody on it, you should have problems right there, because number one, you're not the owner as long as the home is owned or the real estate is owned in the estate name. Problem number one. And realtors need to know that too. That should be a red flag for any realtor. If you go to sell a property and you're selling it in an estate name, then you know that probably a court of a local jurisdiction needs to be involved.
Look, I cannot say it any better. Hey. So we have to understand, folks, that when you do have someone that has passed away, mother, father, other family member, and let's say that you are the sole heir to that property, it is very important that you try to get that property into your name as soon as you can. Because here's where I tend to get these cases. Realtor has already signed this person up. They get a contract for sale. And then it goes to the title commitment, and the title company says, where are your probate documents?
Right.
And guess what? This usually happens right in the middle of the sale. Closing date is a couple of weeks away.
Okay.
And now you, the heir to the property, are coming to me or Lisa saying, I need. Well, guess what?
And what had happened was, what happened?
Guess what? The court process does not bend to you just because you decided to follow the wrong steps.
Yeah.
So what can you do as heir to property? It's important that before you sign any agreements, that you put everybody on clear notice. I don't own the property. This was my mom's property. Second, when it comes to timetables, especially when it comes to closing, you need to be clear with your realtor and make sure that the realtor is clear with the title company and the buyers of the property that this is subject to probate.
Oh my goodness. Oh, wait, but there's a conflict right there because buyers and sellers, they make their own timelines in the sales and purchase contract. And we've always been told and tell everybody else that that contract is your Bible of the deal. But now you got another matter of probate court trumps all the timing of the entire deal. And that has to be recognized within that contract. And I know what Sandy's getting ready to go into. Those timelines generally will have to be adjusted to the probate court timeline. And that's where a lot of people get off track.
I mean, Lisa, we've had a couple of transactions together. How many times have we extended? Many times we're extending 1, 2, and 3 times. And potentially your buyer may be like, nah, I don't want to do this. Why? Because nobody was clear on what's happening in the situation. So you, as the heir to the property, number one, if you're entering into any agreements, you have to understand what capacity you're entering into those agreements as. You're the heir to the property, but you don't have any legal control over that property. Right. So that's going to be a big issue. The second part is when you do end up going through the probate court process, you're going to have some grace with your attorney because you're now coming to them with a pile of foolishness. And they shouldn't have to deal with that nonsense, right? You should have spoken to an attorney before you started that whole process, right?
Yeah.
And then the other thing is keeping in mind, when it comes to the contract is a contract. So if you sign that contract and something happens to you, that doesn't necessarily mean that the contract is eliminated, right? And the other thing is understanding that if you have a contract, there are terms and conditions in that contract. Yes. So you have to make sure that you don't get yourself all rushed because your realtor wants to sell, that you don't get yourself rushed because the buyer wants to buy, that you don't get yourself rushed because you see the bottom line, that number that you're going to get as the profit from that sale. You have to make sure that the terms of that contract satisfy where your status is, satisfy the timetable that you're on, and that people are clear that there may be some need for extensions in advance.
Right. And it's not impossible, obviously, to get through the transaction, even if probate court is involved. Right. So even if you're the only heir and there's no one to fight you against anything, you still have to have a probate estate open in the case where you're an heir of an intestate real property. Absolutely. And you open that estate and you have to petition the court to basically get the property sold. That is the process. So you don't just get to sell it because it's not your property yet. So you must petition the court for that sale. And that's where those timelines have to be adjusted. A lot of these courts, they work pretty fast. But if you're in a court situation and the court's moving slowly, you have to deal with that within the sales and purchase contract for the property.
So, we got to go to a second scenario. Hey, we don't play. We don't play. We don't play. So the second scenario I need you to understand is this. Many times when we have heir property, there is one person that is really handling everything, right? That
Mhm.
one child that is dealing with all the stuff. And then there are the others. The
Mhm.
one that lives in the property and has paid nothing.
Okay.
The one that thinks they're entitled but has been nowhere to be found all the times that mama or daddy needed some assistance. The one that disappeared years ago, nobody's seen them in ages. And then
Okay.
of course the one
Hello.
that's handling
Hello.
everything, right? So
Hello.
here's some other problems that can happen, right? The one that's taking care of everything, that's probably put money into the property and done all kinds of things and is paying the bills, also has this false sense of I'm entitled to this property, right? Please understand, when it comes to heir property, your state will dictate how property is divided. And I will say more likely than not, it's going to be divided even Steven.
Right.
So that means it doesn't matter that you put more money in. It doesn't matter that you did, like, you're not automatically entitled to the property. Now, there may be some processes and procedures depending on how much money you put in and things like that. But ultimately, what tends to happen is you're forced to sell the property because no one can be on the same page about, hey, I want to keep the property since I've already been putting all my money in. Well, the rest of them are like, well, I want my money. So I don't care what you want to do. That's a problem, right?
That is a problem. Hey, Rigo. Want to give a shout out to Rigo checking in with us here. We
Rico's
appreciate you.
tuning
Yeah,
in
we
on
do.
Facebook.
Definitely. But yeah, that is a problem because like Sandy just said, it could be several family members. What if it's nine of you? What if
Yeah,
it's nine siblings and only one, as she just stated, is doing everything to maintain the property, paying the taxes, keeping the grass cut, making sure there's no code violations. And so this person feels like, I'd like to keep this property in the family, but everybody else says, no, it's payday. I needs to get paid.
right.
Then, like she said, that creates a conflict, and generally that leads to some type of sale.
Yeah,
Except in the state of Florida now, there's one thing that's really great that Governor DeSantis did do, and there is a new statute with regard to heir property. If your other heirs who have an ownership interest want to sell their interest, they can't just go out and go to Joe Blow investor without giving the other heir, sibling heirs, family member heirs, an opportunity to purchase that property. Now that's one thing I do like, because a lot of these forced sales used to happen because investors would
right,
get a fractional interest and then they wanted their money and would force a sale of all of these folks who just wanted to keep the family property. Now they
right,
have to sell it because Joe Blow investor wants his money. So that part I think is good. But we need to be strategic about this as well. We need to think about who's going to take care of this property. Do
right.
you put it in all nine family members' hands?
Mm,
Or do you give it to the ones who are likely to keep that property and maintain it as some type of family legacy? That's what folks have to think about these days when they're giving away heir property, even in a will, because you can create heir property in a will. If you got nine folks in a will, you can give it away like that, and it's still heir property in that sense because everybody owns this little fractional interest. Well, I shouldn't call it, it wouldn't be heir property, but it kind of creates that scenario of many different owners. You can do it in a will, or you can do it like Sandy's saying by statute when you don't do anything, and then people just inherit. 90 people inherit the property all at once.
oh Lord.
I just it's very nightmarish that
Yeah.
people don't think about that. Should 15 people end up owning one piece of property? Should that be happening out there?
My opinion, absolutely not. I think and I talk to my estate planning clients all the time about choose somebody. As the parent, I know that you have all these great intentions and think all the kids are going to get along when you pass and they're going to all come together, kumbaya. Choose somebody, right? If daughter A already has property and daughter B already has property, then leave it to daughter C. Like,
If daughter
what's
C
wrong
is
with that,
responsible,
right?
and daughter C is not a crackhead,
Right.
and you go out there and gamble all the way,
Yeah,
gamble away at, yeah, leave it to the ones that are really responsible. Not everybody knows how to even take care of real estate. Some
absolutely.
people don't realize you have to pay property taxes to keep the grass cut, or, keep repairs made. You have to really think who's responsible here.
And truth be told, if you want to control what happens to that property, you may have to have some device in place like a trust where you can say, all right, the trust is going to pay for the real estate taxes and if there's a mortgage and the maintenance, and daughter A or son A or whatever can live on the property for their lifetime. And once they decide to move, property will be sold and the money divided. Or once they move out, maybe it'll be held as an investment property and the money from that will be divided equally. Like, there's so many different ways to do this, so there's no reason for anybody to be passing away, leaving property and having 10 people on there, right? And then keeping in mind too, one situation, and this is the last situation, one situation where you have somebody that passes away and people just live in the property with no regard for the fact that there may be issues that come about. Then 10 years later, we need to probate it because we need to sell it. So now I'm having to deal with 15 degrees of people, right? I have to deal with the children and then the children of these children and the children of that child. And the person died here. So I have to deal with the grandniece and grandnephew. Like, come on.
Why?
So, I really think that people need to consider their options when it comes to heir property. And if you own a property right now, you should be making plans for that. That's why estate planning is important. So it shouldn't be heir property. We need to do some estate planning and make sure that we put our stuff in place.
Absolutely.
So that's all I got to say. That's my
soapbox. Otherwise, you're going to take it to the house. And when you get to the house, you're going to realize you don't own it.
Oh, shoot. Hey. Like, this is just, we don't play. We take it to the house. So guys, please note that we are on here live every Wednesday morning at 10 a.m. We try to keep it brief. We're at the 16-minute mark right now, so we're going to try to cut this real short. Today we were talking, can I sell mama's house? Heir property problems. If you have an heir property scenario, feel free to reach out to us. You know that you can reach us, guys, using our email address, learnbizllc@gmail.com. You can also DM us on social media at B is for BIZ. But always, guys, always make sure that you tune in to join us on Wednesday mornings. And Lisa, let's see if you remember us saying, like, let's see if you remember how you're going to close it out.
Well, what I'm going to say is, if you fail to plan, I'm going to send it over to Sandy for the rest of it. But if you fail to plan, Sandy,
you plan to fail, y'all. You plan to fail, and then you're going to have to take it to the house. Hey, have a good one, guys.